as I understand that we have less time, but we'll try our level best to kind of, do the justice to this panel. So we have witness determination of damages in arbitration. For that, I would request Mr. Gauhar Mirza, who's currently the partner at Cyril Amarchand Mangaldas, to come on stage, please. So he is an experienced advocate with history of working in arbitration, mediation, IT, and criminal law. And he's done a lot of arbitrations, domestic and internationally. I would also request Mr. Avnish Mishra, who's currently the Assistant General Manager Legal with Kirloskar Oil Engines Limited. He's a company secretary and a lawyer by profession, and he's worked with various companies in the past. And he's been recognized as one of the best legal counsels at various forums in India. Welcome, Avnish. And I would also request Mr. Namit Suri, who's currently the Associate Partner at Lex Indus Law Offices, AOR Supreme Court of India, to come on stage. Namit heads the litigation wing of the firm and brings loads of experience with respect to arbitration and various fields. He's been actively at Supreme Court and High Court of Delhi. So welcome, Namit. Thank you so much. Very basic question to all of you, but I'll start with Namit. You can just take the mic. Just wanted to understand that what's your thought process and take on the arbitration of 1996 versus 2019? What basic transformation you have seen from 1996 to 2019? Over to you, Namit.
Yeah, so I understand also the paucity of time which we are facing. So I'll quickly wrap it up in about 6-7 sentences. So the landscape of concept of damages has changed over the last 50 years, and I would, for the benefit of my audience, Hello?
Yeah.
Hello? Am I audible? Yeah. So for the benefit of my audience, I'll just quickly refer to 2-3 judgments which I think throw light as to how the concept of damages has changed, starting from Fateh Chand, Maula Baksh, and the latest, I would say, the Supreme Court on the issue is Kailashnath versus DDA. And as far as the concept of damages is concerned, today the sum named in the contract is not automatically payable, except as much as an individual who is alleging breach has to demonstrate before the courts or before the arbitrator that he has suffered loss. So this is how the law has changed, and earlier as to how people and how general population as to the fact used to understand loss has changed. Now each and every rupee which one claims towards recovery has to be demonstrated in the form of loss, except as much there are 2 circumstances and 2 exceptions. A, that you are able to demonstrate that the sum named in the contract is a genuine pre-estimate of damage, and for that also the burden is upon the person alleging breach. And second is that if you can demonstrate and plead to the effect that the nature of the contract is such that that damages cannot be proved in a given circumstance, that the court does come to your rescue. So these are the 2 exceptions. Thank you.
Yeah. So thank you, Namit. I would just, bring the dice to Gauhar. So Gauhar, in your experience, and you've been a practicing advocate from, inception when you did your law. So what is your take as a private practitioner from 1996 to 2019?
So I think, thank you for the question first. A lot has changed. In 1996, of course, it was at a very nascent stage. The biggest amendment that had come was in 2015, where the concept of automatic stay was removed. Prior to that, we had seen the judgments of Bhatia, Balco, etc., etc. So all those problems that had happened earlier, prior application of Part 1, Part 2, that was trying to be, in the legislature tried to take care of it in 2015. But 15 also, okay. And after 15, the major amendment came in 2019, where Part 1, Part 2 again was considered, and the distinguishing factor that whether a Section 9 can be filed with respect to international arbitration, etc., was introduced into the 19 Act. But as we all know that it's an ever-evolving space, ever-evolving law. We are still seeing a lot of changes to it. Recently, we have seen the latest bill that has come in, which is trying to bring in a lot of changes and adopt a lot of things out from outside of India into the Indian system. So I think that is something to be seen. But yes, from 1996, where as a practitioner, I started my practice in 2010. But when we saw arbitration in 2010, and what we see today, I think the numbers have increased. In 2010, we used to have one arbitration in a month, and today we have at least 2 arbitrations a day. So I think a lot has changed, and a lot has to be given to the law. The changes that has been brought have been brought in. And in the field of arbitration, at least what we see is that everybody is a stakeholder. The litigant is a stakeholder, government is a stakeholder, the practitioner is a stakeholder, the judiciary is a stakeholder. So I think everyone is just trying to contribute to it. That's, I think, what change I have seen.
Sure. Thank you so much. So Avnish, over to you. Just wanted to understand your thought process from the 1996 to 2019.
Thank you, Love. Good evening, everyone. So while my co-panelist talked about the evolution since inception of the act and then how the things gets added to it and the way economies worldwide are evolving, I would like to throw some light on the best practices what I have experienced, that how the technologies are being leveraged to address to these kind of challenges. More and more usage of technologies are coming into the play, using virtual forums for attending and having the meetings and setups are also being implemented. And what I've also seen that standardization of process and focus on improving efficiency has been increased. As you rightly pointed out, Gauhar, that now the cases are also coming because people are relying that, okay, this is the forum through which we could get the justice in real quick time rather than getting into the expensive litigation. So focus on process improvement and standardization also what I have seen. And one important and particular point is also that the greater reliance on the independent expert is also coming into the play, wherein the court arbitrators are relying on the independent expert to comment upon the subject matter. And also what I would like to say that like standard statistical modeling approach is also helping now the courts to conclude the quantum of the damages. It becomes very easy for them to apply a few of the statistical models which will give them proven result in terms of determining the quantum. So these are the few best practices I would say I have observed as and when we are evolving with this law. Thank you.
Thank you, Avnish. So, Namit and Gauhar, I think you people are, currently practicing professionals, and I want to understand specifically on the topic that whenever an award is being, proceeded basis the hearings between the parties, how do you see determination of damages takes place, and what is the best practice you would actually inform your clients, because it has to be watertight, and if it's not watertight or it's not very concrete, then you can actually face a lot of challenges through appeals and everything. So what is your thought process on determining of the damages in an arbitration award, and what are the best practices which you can suggest as a practitioner?
So thank you for the question, Love. So I'll give an example of a real case which continues to be sub judice before the court, and how, as I indicated in my initial response, the concept of proving damages as understood by the common man has undergone a change. And there was this matter in which a very successful doctor working at a hospital was, as per him, allegedly illegally terminated. And he understood the fact that, and there was a lock-in clause in his contract, and he filed his claim and claimed the balance of the lock-in period as the amount of damages which he quantified that he would have suffered and has rather suffered on account of the illegal premature termination. And ultimately before the arbitrator, because as to how his counsels had understood laws, he just filed the claim on the basis of the balance lock-in to be the damages which he had suffered, without taking the pains and without actually leading evidence for the alternate employment which he had which he would have actually tried to obtain without leading evidence to mitigate loss, and simply understanding that the balance lock-in is the amount of damages which he would suffer. Unfortunately, the claim was turned down, declined, and he has challenges in a 34. So I would taking this as an example, would guide the audience sitting here that the best way to quantify damage today is to identify the loss, try and prove the loss through whatever evidence you can try and obtain, and ensure that you can come as close to proving the loss through the evidence as you have claimed in an arbitration through alternate employments, as in, for example, I'm referring to this case is concerned, or for in case where you say losses have suffered, you try and lead evidence to demonstrate as to the loss which you have suffered on account of the illegal termination, premature termination, so that the arbitrator has some basis, he has some cogent material, he has some evidence before him to grant you loss.
Would you just like to add on to what Namit has stated?
So I'll just pick on your question that what are the best practices that one should tell to the client. First is that an expert has to be taken very seriously and very, very efficiently. Expert is not somebody who is going to escalate your claim from 10 crores to 100 crores. That is the first mistake every